Thanks for joining us. The webinar topic for today is the process of divorce in Washington State. I'm going to be joined here in a moment by Michelle Dellino of Dellino Family Law Group, and she's going to be presenting at the webinar today. My name is Melissa Rosenberg, and I'll just quickly introduce myself. I am actually a therapist who specializes in the area of working with clients dealing with divorces and relationship transitions. I've worked with both individual clients and also couples navigating these challenges. Today, I'm here in the context of facilitating this webinar. And so what I'm going to do is turn it over to Michelle here in a few moments to introduce herself and begin presenting some information about the process of divorce in Washington State. But I'm also going to take questions. And so just to let you know a little bit about how that works. You can see at the bottom of your Zoom screen, you have a Q&A. There's also a chat option. If you want, you can ask a question during the webinar. We'll try to get to as many of those as we can. You can do it in one of two ways. You can ask a question through the Q&A. And when you do that, you can mark yourself as anonymous, or otherwise your name will pop up. If your name pops up, then other people on the call can see who asked the question. Or you can put anonymous and then it just says anonymous member asks the question. If you put it in chat, that question will only come to me and I will then pitch it to Michelle. So feel free to send out some questions during the course of the webinar if you have any. Sometimes people, if you're just here to listen, that's great too. Somebody else might ask a question or you might hear something that's brand new to you today. So that's the basics, and we'll be here for an hour-ish and hopefully begin to present some information that'll be useful to those or who are here with us today. So thanks again for being here, and I'll go ahead and turn it over to Michelle.
Hi, I'm Michelle Dellino. I am the owner and managing attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we handle cases all over Washington State. So today we are here to talk about the process of divorce. And really, I'm going to touch on some things that are not procedural, and I'm going to try to get through as much of the procedural process as possible. So there's kind of the soft factors, and then there are the more hard factors that are the procedural ones. So I'm going to touch on both of those. I've been practicing family law for almost 15 years. I've seen pretty much every kind of circumstance that could happen or come up that you might face, either in my own cases or cases of other attorneys in our office, and can tell you firsthand that if you are here because you don't know what to expect, you're scared about divorce, you're worried about divorce, anything like that, you are not alone. Almost everybody in your situation feels that way. Or if you are in the middle of divorce, this is the other thing that nobody talks about. You're in the middle of a divorce and you're frustrated. Things aren't moving as fast as you want. You don't understand what's going to happen next. You don't understand why there aren't certain answers. All of that, if you're feeling any of that, if anyone's here that's already in a case, it's all very normal. Or you want things to go a different way than they're going. Also very normal. So what we're going to talk about in the very first place are a few of the soft factors, and then I'm going to get into some of the procedural ones. And like Melissa said, if you have questions, I will stop it a few times during the webinar to take questions. So be sure and let Melissa know. Anything that I say today is meant to be information. It's not legal advice. I'm an attorney, but I'm not your attorney. Unless you happen to be my client on this webinar. Maybe some of you are, I don't know. But if you are my client, we have an established attorney-client relationship outside of this webinar. If you are viewing this webinar, nothing that I'm saying should be taken as legal advice. It should just be seen as information to inform your situation. If you have very fact-specific questions and you ask those today, we might not get to them because I can't provide you necessarily a step-by-step fact-specific explanation of what's going to happen in your case. You should consult with an attorney on your own, whether that's me or someone else's. Totally up to you, but the reality is you need to get sometimes really into detail on your case. So this is just general information. With that being said, let's get started. First thing is you or someone else is going to make a decision about, sometimes both parties, but someone's going to make a decision about filing for divorce or legal separation. I wanted to first address that. Sometimes a decision will be made for you because you'll be served paperwork or someone will tell you, hey, we're getting a divorce. Other times you'll be the one making the decision. If you're the one making the decision, things are easier because you kind of know, hey, when this is going to happen, you know the next steps that you're going to take. Things start to feel a little bit more manageable, but that's not always the case. Sometimes you're the one who is not making the decision. Or sometimes you're making the decision together and it's still scary. That's totally normal. Or if you're the one making the decision, even though there's more certainty, it doesn't mean it's not scary. So There are two types of actions that you can file when you make that decision or when someone makes that decision for you. One is a divorce, also known, it used to be called specifically a dissolution of marriage, but now we have changed the name in Washington to the more family-friendly terms like divorce. So divorce and dissolution, if you hear either one of those are somewhat interchangeable. The second thing is legal separation. Some people will choose to file for a legal separation, and we'll get into the differences of those. Those are the two actions that you can file that end your marital community. What is your marital community? We'll get to that in a minute too. So first, let's talk about divorce, because and then I'll talk about the differences between that and filing for a legal separation. Divorce in Washington. If you have kids, you're going to have 4 primary issues that you need to work through. If you don't have kids, you're really going to have 2. So I'll tell you what the 2 universal issues are. The first one is going to be division of debts and assets, division of your community property and separate property. We'll get into that more later. So division of debts and assets. Number 2, in every case, there's going to be a question as to whether there's going to be spousal maintenance. Spousal maintenance might not be a factor in every case. A lot of cases don't have it at all, but whether there is going to be maintenance is going to be a question. So that's another thing. And so those are the 2 things in every case, whether you have kids or not: spousal maintenance and division of debts and assets. If you have children, you're also going to need to establish a parenting plan, and you're also going to need to establish child support. So those are kind of your big 4 issues. There can be other, what I would call ancillary issues that go along with a divorce with or without children. Those can include restraining orders, protection orders. They can also include payment of attorney fees. So there are other little issues that may come up in your case, but are not necessarily required to be addressed in your case. The big 4 are division of debts and assets, spousal maintenance, parenting plan, and child support. Okay. So when you file for divorce, a lot of people want to know, how long is this going to take? It's going to take at least 90 days, and that's a very fast divorce. Most divorce cases don't have anything happen in 90 days unless it's either totally agreed on or you don't have anything. Any divorce that has any amount of assets or property is going to take longer than that. But the legal standard for how quickly you can get divorced in Washington state is 90 days. On the 91st day from the date that someone files and then makes service on the other party either has to be personally served, or they have to sign something saying they accept service, or they have to sign what's called a joinder, which means they join in the petition. One of those 3 actions has to be taken once the case is filed to start that 90-day clock running. That's the soonest. I think a helpful thing for people to know would be that if you have debts and assets, I used to tell people it was more like 6 to 9 months in a lot of cases before COVID, but things move a lot slower now. We do things a lot more virtually now. The court calendars are busier now. There's actually a lot more people in this area now in King County, so the courts are very busy here. It takes longer to get hearings. It takes longer to do a lot of things. So I tell people now, if you have debts and assets, you are probably thinking, and kids, I want this over now. How soon can this be done? A friend of mine, his name is Rafe Palmer. He has a book that's called I Just Want This Over. I think that's what it's called. Something like that. I can't remember the phrasing right now, but the effect of it is, I want this done right now. And so Rafe works through that's not going to happen. It's going to take longer. And he wrote a whole book about it, and it's a very good book. But the point is, it's going to take you longer than you want. A divorce is a marathon. It's not a sprint. A sprint to the end is going to give you a result that's not going to be the best result, because you're not going to have all the information. You're not going to have the opportunity to negotiate. How long is it going to take? Well, if you're in King County, you will get a trial date in the beginning that's like a year out from when you file. Is it going to necessarily take a year? No. Parties can reach a resolution a lot sooner than that through mediation or agreement. That can definitely happen. But that trial date gives you an idea that if things move along and it takes longer to get to mediation and there's more contested issues, it could take a year, it could take more. I used to say 6 to 9 months was an average years back. Now I kind of say 9 to 15 months, because it's not uncommon for your trial date to get continued. It's not uncommon for there to be a guardian ad litem investigation, or a need for a lot of discovery, or any number of things that kind of pushes the can down the road. So that's a timeline for you to think about. Legal separation is another thing to think about. In legal separation, this is the thing for everybody to know. You're still going to divide the assets. You're still going to potentially have spousal maintenance. You're still going to have a parenting plan. You're still going to have child support. You have all of those things. The only real difference is you're not actually divorced. You can't remarry. So sometimes people will say, why would I file for a legal separation? One reason that you might file for a legal separation is if your employer allows you to keep your spouse on benefits, even though you are actually legally separated. A lot of employers won't. A lot of employers will say that a decree of legal separation entering ends benefits. Not all of them, though. So that's something that you might want to check into, and it's going to be fact specific based on your employer. But the reality is you are financially separated after a legal separation. You will file taxes as single. You are financially and legally separated. So the marital community has ended, even though you are still married. So it's a little bit confusing, but everything is still divided. The process is still the same. The other fundamental difference is there's no 90-day waiting period for legal separation. You could be legally separated like tomorrow if everything was agreed. And then this is the other thing for people to know who are considering legal separation. 6 months from the date of final order in legal separation enters, 6 months from that date, either party can move to convert a legal separation to a divorce. So what that means is the other party can't stop them. So some people will do a legal separation because they feel it's going to be better received by the other party. They want to start out on that note, and then they might intend to convert it to a legal separation later. To a divorce later. That definitely happens. Or they might just feel uncertain themselves, and they might want to think, hey, I could, go back on this, or it just gives them that peace of mind. Some other people, mainly when I've had legal separation, it's either been for benefits or it's been for religious reasons. Certain people don't believe in divorce because it doesn't comport with their religious identity. If that's the case, then sometimes they go legal separation. But my advice to people is usually, if it's not a benefit situation, and it's not something where you're kind of trying to baby step the other party into this idea, and you want to be divorced, just do the divorce and save yourself the trouble later. But either way, yes.
There's a few questions, but there's one on topic here, so I just wanted to ask.
Yeah.
The participant asks, what if my spouse files for legal separation, but I want to file for divorce? Should I wait 6 months in that case?
No. If your spouse filed for legal separation, when you respond, that's a great question. I'm happy that someone asked that, because I was going to touch on that, and this just makes me answer it more succinctly. If it's sometimes that's what'll happen, is someone will be like, oh, I don't want a legal separation, I want a divorce. If that's the case, when you respond to the petition, you can say that you want a divorce. And then when you finalize, if someone wants a legal separation, someone wants a divorce, you're going to finalize as a divorce. You don't need to file competing petitions, though, because then someone will have to dismiss one of their petitions, and it kind of just creates more work that you don't need to do. So what I would do in that situation is respond to the petition, state that you want a divorce, then you'll finalize the case as a divorce. I've had many cases start as legal separations, and then we finalize under the same cause number as a divorce. So that's a great question, and there's ways to do that. I should probably touch on one other thing I just thought of, because I just finalized one. There is one other kind of action. The other action is called an invalidity action. Some people will say, I want to get my marriage annulled. And I just did one of these, and they're really uncommon because not very many things qualify. Not often does someone qualify for them. But I've done a handful of them over the years, and I think it's important to touch on just in case anyone's wondering about that. So a legal separation, a divorce, and then the other action in Washington, well, there's two others, but the only other one I'll talk about today is invalidity. And invalidity is what some people call an annulment. Annulment's not a term in Washington, but invalidity is. You can get a declaration of invalidity saying, my marriage was invalid, it never happened. And there are very specific rules in the state of Washington that basically need to apply to your circumstances to be able to get your marriage invalidated. If you do not fall into these categories, and there's not very many categories, you're not going to get your marriage invalidated. They're going to be like, sorry, you need to get a divorce because you were married and whatever. But I did just finalize the invalidity, so it made me think of it. An invalidity action is appropriate if the parties didn't have capacity to contract. So one I did recently, both of the parties were under the influence when they agreed. So it's basically a marriage is a contract, and they didn't really have capacity because they were under the influence and they couldn't make a good decision. And So if parties lack capacity to contract, either due to being under the influence or one party being mentally incapacitated, that can be a reason to invalidate a marriage. Another reason can be force of fraud or duress. I did an invalidity once where it was basically a marriage for a green card, and the parties never lived together. Somebody was given a payment to marry this other person. That's an invalid marriage. It's a fraudulent marriage. Other times, another one I did that was a little bit more unique, but sometimes falls under an exception, is the parties got married. They never consummated the marriage. They never lived together. They got married and then they just decided, what are we doing? And they never lived together or were together as a married couple. And that also can be a basis, although it's pretty rare. You can't just, those are kind of the primary: force or fraud, incapacity, or fraud with respect to the essentials of marriage. Like you never lived together and you never really were married, like besides in name only. And maybe you didn't hold yourselves out as married, maybe even nobody even knew about it, and then you just never lived together that way. So there's a few different ways that you can get your marriage invalidated, but what you can't do is say, oops, I made a mistake, and I moved out and now I want to pretend it never happened. You have to get a divorce in that case. If you lived with a person, you got married, nobody was under the influence, nobody was threatened, nobody was paying the other person for a green card or anything like that. So if that's the situation, then you need to go divorce. So that's all I'm going to say about invalidity before I forget. Melissa, is there any other questions before I move on?
Yeah, there's a couple of questions off different topics, if that's okay.
Yeah.
So, okay, so, some of these I'm just going to let participants know are kind of specific to your case. I'm going to try to ask them, but we need to answer them in more general terms if we can. So one participant's describing, she's 64, hasn't worked in 12 years. Husband's also 64, wants to work till he's 70. What are the best options as far as my own financial stability? Divorce now or when we're 70? Is it better to separate? Again, very case specific, but maybe you can just talk about kind of retirement age and financial stability and what are the benefits of waiting or not waiting.
I'm going to talk about long-term marriage. So
Yeah.
I'll come back to talk about long-term marriage. But before I will put that here, but I will come back to talk about long-term marriage. This came up in another recent case of mine too, was how long is one party reasonably expected to work? If this person's husband, I think they said husband, wants to work till they're 70, that's great. And they can work until they're 70, but a court also won't force them to work until they're 70. So I just had this in a long-term marriage case of mine where the parties were almost early 60s. And one party says, I'm going to retire at 62. And the other party says, well, you should be paying me maintenance. You need to work longer. Well, the court's not going to make somebody work past 65. I mean, at the latest. So anyway, I will talk about long-term marriage. Anything else, just so I can make a note of it before I move on?
Yeah, I mean, I think kind of in that case, the question's kind of more around, is it better for the person who is looking to separate to wait 5 more years till their partner potentially stops?
I think it depends on the specifics of your situation. I mean, I don't know that you would necessarily, sometimes it's actually better not to wait. I'll just touch on that. Sometimes it's better not to wait because you're dealing with the spousal maintenance question. And if somebody's retired, you're not getting spousal maintenance from them. You're probably getting an equalization of benefits. You're probably getting, if it's a long-term marriage, I've been married, 25 years plus, you're probably getting an equalization of benefits, or retirement income, but you're not getting spousal maintenance if someone's not working. So if you want to be able to be separated, and it is a case where maintenance is appropriate to be paid by one party or the other, and that party is still working, then you have that opportunity to get it. But that's where the conversation comes in, and what I was mentioning, that a court's not going to say, hey, you're 61, you've got to work till 70. This has come up in a couple cases lately where people have thought, well, they're going to work till 70. But then you have the other side of the coin where if the parties enter into an agreement that says, hey, we're contemplating retirement now, and neither party working, so there's going to be no spousal maintenance. I have also had circumstances where parties have done that. Maintenance has not been non-modifiable, meaning it can change later. And then someone will come back later and be like, hey, he or she is still working. Now I want maintenance, and the case could be reopened. That could happen too. So if the parties are not going to be working, it needs to be specific that that's non-modifiable. Otherwise, if you have a long marriage and then someone goes back to work a year later and is making a couple $100,000 a year and somebody's not making anything, that's not equitable. And if the agreement was made on the premise that no one's working, that's a different thing. So as far as whether you should wait or not, it also probably depends on the overall financial picture that you have. So that's pretty fact specific, but hopefully when you're thinking about long-term marriage, you're going to need to think about things like Social Security benefits. You're going to need to think about retirement. You're going to need to think about if there are any pensions. You're going to need to think about insurance and who's going to be eligible for what and who's going to cover what. You're going to need to think about life insurance as well. And if there are any policies with cash surrender value or they're going to pay out on retirement, there are different whole life policies that do that. So there's a lot of special considerations in long-term marriage. I really like long-term marriage because it's really about long-term marriage divorce. I know it sounds weird to say, but I like it because it's really about setting people up for that last phase of their lives, and there's special considerations. So if you have a spouse that's going to work till they're 70, and you want to stay married until then, great. If you want to get divorced, you're going to want to make sure that you account for that in negotiating your spousal maintenance if one party is going to be paying it to you. So I hope that helps.
Thank you. Yeah, we've got a ton of questions. So
okay, how about this? How about this?
Yeah.
All right, I will take one more, and then I'm going to talk about the basic approaches, and I want to talk about financials, because I think there's a lot of misconceptions surrounding financials and divorce and the need to be transparent on financials. I've had this come up many times, not just with my own cases, but cases in our office where people will ask me like, oh, is the other party going to know about this? Are they going to know about that? Why do I have to give the other party my financials? This comes up a lot. So I want to be sure to talk about financials when we talk about this process. We've talked about the timeline for divorce. We've talked about the differences between that, legal separation and invalidity, but I want to talk about the different approaches to divorce, and I want to talk about the financials. But what I'll do is I'll take, it's 12:21. So I'll take, how about one or two more, and then I'll go into those areas of discussion.
Participants asking, how does the time before the marriage count for the divorce?
I wasn't going to talk about that, but
yeah.
because I could talk
maybe if a couple is domestic partners or living together.
Yeah, I will talk about it. All right. I wasn't going to talk about it because I said, oh, I'm not going to talk about that one other thing. What I was not going to talk about was committed intimate relationship, but you got me. Now I have to talk about it. I like talking about it, but I did a whole webinar on it before, so you should watch that. But anyway, okay, committed intimate relationship, because Washington has a doctrine of committed intimate relationship law, and that doctrine really came to be in a case called Connell versus Francisco. And that's a very specific case that lays out 5 factors that a court will consider in Washington to determine whether unmarried couples, either before marriage or even if they never got married, existed in what's called a committed intimate relationship. Why does that matter? It matters because community property can attach to that premarital period. That's what you're asking about. So, okay. Let me give you my favorite example. My favorite example is I had a case a few years ago. It actually ended up being a trial case, which was kind of strange, but parties were married for a year, literally like 13 months, barely a year, right? So not a lot to fight about there. But they lived together for, I think, 12 years before that. So if you lived together for 12 years, then you're married for a year, really in that circumstance, the issue was we were looking at a 13-year division of debts and assets. One party wanting to say there was no committed relationship before we got married, the other party being like, well, of course there was. We were together 12 years and then we got married. So the first question is whether that premarital portion is essentially a good case to be a committed intimate relationship. Most of the time when the parties get married, they have children, it is. But if you just live together 6 months or a year beforehand, that's not significant enough. It needs to be at least a couple of years to really add on that extra period for what we don't call it community property, we call it community-like. It used to be called quasi-community property. That just means that continual cohabitation period, even though you weren't married, could mean that assets that were earned or acquired during that time are subject to division. So I hope that answers your question. There's a whole other webinar on it if you want to watch it.
And what about time between separation, like when somebody moves out and then maybe the divorce? Does any of that count toward length of alimony payments or I guess spousal support payments?
Yeah, that's a great question. And I will talk about spousal maintenance, but let me talk about data separation since we're still talking about the mechanics of divorce too. This is really important. Okay, this is another example I will use. A lot of the time parties, this is the thing, the longer that you wait from the time that you separate and actually do your divorce, kind of the more complicated things can be. And the reason why, and you wouldn't think that, but it's actually true if you have assets. And the reason why I like to use this example is I had a guy where he was my client, I did the divorce, and it was a number of years ago, but they were separated for 13 years, living totally separated for 13 years before anybody filed for divorce. And they did that for a number of reasons. And I'm not saying it's right or wrong, but it made things more complicated because we had to then go and look at There were several retirement accounts. There was an employee stock purchase program account. There were a few taxable accounts. So we had to look at those accounts because when they separated 13 years ago, their marital community ended. Even though they're still married, they separated. They established a date of separation. Everything after the date of separation is separate property. So if my client, who I was, I think, working at Microsoft at the time, is working there and he has a 401k from Microsoft and he worked there during the marriage and then 13 years after the marriage, that account now has mixed character. So there was a community portion and there's a separate portion. You might think that'd be simple. You just look what the account was worth and what it's worth now, but that's not the case, because you need to then get a valuation done to determine what were the gains and losses now on the separate property portion and the community property portion. And so there's a calculation that needs to be done based on the accounts. So that means you've got to go back and get separate valuations for all of these accounts. So if we're only talking about, like, not very long, that's not that big a deal. And a lot of times people will agree to value things at different points. But if you're talking about a long time ago, you've got to get valuations on all those accounts. Anyway, long story short, the point is, once you separate, after there is a date of separation, assets or debts acquired after that point in time are separate property. However, and this is the key thing, and this is, I guess this is good because we're touching a little bit on the financial stuff I wanted to touch on. All property is before the court. The court gets to know about everything. So even if you're not in front of the court, if you're in a mediation or you're just negotiating, both parties get to know about everything. A lot of people don't understand this. All property, separate, community, doesn't matter. It all has to go in your spreadsheet. It all has to be included. And the reason why is because, especially in longer marriages, courts can invade separate property if they want to, and there needs to be a final division on all property. So yes, you have to be transparent about all financials. You can't leave things out. If you leave things out, those are basically omitted, and depending on the settlement agreement that you sign, usually you're agreeing that if you omit something, the other party is not entering into a knowing and voluntary agreement. It could be a basis to invalidate the agreement. It could be a basis to award a disproportionate division of what you hid or left out to the other side. So you need to be very careful. You need to not think that you're going to be able to hide things. So, however, sometimes people don't disclose things and other people don't find out. I mean, that's the reality of it, but a lot of the time they do. So it's good for you to understand that you will have to exchange financials with the other party for two reasons. One, they can't enter an agreement. Neither can you. You can't know what a good agreement is unless you know everything. And then two, somebody can't actually advise you. Like, I can't advise a client on what would be a good deal for sure until I've seen it. So a lot of the time, if I don't have the financials, I just have what the parties are telling me, I can be like, well, this is what I think based on this. But if or the other party doesn't want to exchange financials, all they have to do is serve discovery and they're going to get it from you. So you might as well provide them, because they have other ways to get it. And it's going to make your case more difficult and more cost intensive if you don't just exchange financials. So anyway, the other attorney might want to see them. The other party might want to see them. They absolutely have a right to see them. And yes, they get to see all of your separate and all of your community property, everything all the way up until the date of division. It's not uncommon also for this to be a very frustrating thing for clients, because they're like, I provided financials like a year ago, 6 months ago, whatever. Yes, but the other party is going to expect you to supplement your financials a lot of the time, not always, but a lot of the time they'll want to see current statements when it comes to time to settle. So that's just the way it goes. Financial transparency is important because it's going to be required usually for both parties to enter into an agreement and for someone to advise you. Okay, I'll take one more and then I want to talk about spousal maintenance.
Okay, well, before the one more, there are several people who are excited that you started talking about committed into relationships. And we're not going to get into all that, but they've been asking, how do they access the recording that you mentioned? How do they get that webinar that you talked about for an hour about committed into
Well, I don't know, because I don't I wish I could pretend that I was the one that did the technical stuff, like putting it online, but I'm not.
Be on the website. Right?
Well, yeah, what you can do, I think it's all on YouTube. These all get posted on our YouTube channel. Go to our website, dellinolaw.com, go to news and resources. And I believe there's a link there to our YouTube page. So if you want to listen to me talk about committed intimate relationships for an hour, bless you, go ahead. Yeah, go ahead. There's a whole bunch of it. And then if you want to talk to me about it, you can schedule a meeting with me and I'll tell you all about it. But you probably can get everything you need to know unless it's case specific from my webinar. So yeah, go to our website, go to the news and resources page. I believe these all get loaded onto YouTube. That one should be up there by now. So anyway, I hope that's helpful.
Okay, another question. This participant is really unhappy with the ruling of their temporary orders hearing, related to limited time with kids, having to leave the house, child support, all of it. Don't really feel like that was a fair ruling. And so they're waiting for a motion for a GAL situation. So they're wondering about possibly switching legal counsel. Can that be done while awaiting a GAL motion and appeal
Sure,
hearing?
you can.
Yeah.
But let me tell you this. There are two parties in every temporary orders hearing. I tell every client this. If you go to a temporary orders hearing, there's no guarantee what will happen. One party will absolutely be upset. Sometimes both parties are upset. It's never a good outcome. And I'm going to tell you this, and this is not just because I am one, but most of the time it's not your lawyer's fault. Most of the time the lawyer doesn't have control over what the court decides to do. The court has to make a decision, and there's very often optics for a court. If one party makes a lot of money and that's really obvious to the court's probably going to award maintenance and not really get into the weeds on it, because they basically look at a bunch of documents. They have arguments for 5 minutes from each side. They've usually decided what they're going to do before the hearing, and they have a limited amount of time to make a decision. So sometimes it's not the most thorough decision, and somebody's going to be upset. So if you got stuck with paying a bunch of child support and maintenance you didn't want to pay, that's the risk that you took when you went to a hearing. Maybe something could have been done differently. And I have no idea who your attorney was. And some attorneys do a better job than others. But at the end of the day, the court's going to do what it's going to do. And it's probably going to fall the same way no matter who makes that argument. That's just very often what happens. Can you switch counsel? Yeah, of course you can switch counsel. If you're waiting for a GAL, that's kind of when there's a lull in the case. So yeah, you can switch counsel. But you should understand that like your counsel can only do what they can do. I've wanted to do things in cases, but I can't force the other side to negotiate with me. I can't force the other side to, I can't force a certain thing to happen at a hearing. I can go to a hearing and I can hope it goes well. I also can't always protect my client from a hearing, because sometimes the other side is going to just set a hearing and we got to go to it. And my client's the breadwinner and they're going to end up paying maintenance. That's just sometimes that's going to happen. Like I can't change the fact that you make more money than them. I can't change the fact that your spouse lied about abuse and you now have a protection order. I can't change the fact that you don't have, you have a work schedule where you travel a lot and you don't have the kids most of the time, so you're going to pay child support. I can argue for a 50-50 parenting plan for you, and that would help you, but I can't change like your situation. I can't go back in time, make you wish you'd done things differently, and give you a different outcome. I can try to do everything I can, but, and I'm just using myself because I can't speak for other attorneys, but I know a lot of them and we all feel the same. Like we can't, if we could control everything that was going to happen, we'd be doing something different. Like I would be in Las Vegas making a lot of money just playing cards. Because number one, I like to play cards. And number two, I could know what was going to come out, but I don't. So I can't. We can only do, but I like the cards analogy because I can only do what I can do with the cards I was dealt, right? I can't play a hand to not have you pay when you make more money. I can't play a hand to make somebody else agree to something that you want if they won't. Like all I can do then is kind of work a case schedule and say, all right, here's some deadlines we have to adhere to, whether you like it or not, and force the other side. So attorneys can only do what they can do. So before you switch counsel, evaluate whether that's beneficial to you. I think you have to really feel good about the attorney you're working with, but sometimes things are out of our control. We can only do what we can do. We're not miracle workers, but yes, you can switch counsel if you want to, but I would recommend you really think about that before you do.
Thank you. Just a reminder with questions that we're not able to answer case specific things. So if there's a lot of details that I'm not throwing into these questions, that would be why, even though you're
a lot of questions today, it sounds like
a lot of questions. Yeah, there's tons. So let me know. I'm happy to fire.
I want to hit some more of the process.
Yeah.
I want to talk about the different approaches. So I'm going to talk about that.
Somebody did ask about if you could touch on collaborative.
Oh, I was going to. I'm not a fan of collaborative, but I'll talk about it. I have collaborative training. I've done collaborative divorce. I think it can be a great solution for certain people, but I think it's not a great solution for others. Let's talk about it. The three types of divorce I will talk about are collaborative divorce, cooperative divorce, and a full-on litigation divorce. There's also kind of a hybrid somewhere in between. Collaborative divorce is when the parties each sign a participation agreement, and attorneys don't have to be collaboratively trained to do collaborative divorce. I recommend that you work with someone that has been collaboratively trained so they understand what is appropriate in a collaborative divorce, what is not, and they have been trained to understand the statutory process. There is a statutory process, which means there's a set of rules that govern a collaborative divorce. It's not just let's collaborate. That's not how it is. Parties actually have to enter into a participation agreement. Both parties have to consent to a collaborative divorce. Both parties have to sign a participation agreement with their counsel. And from there, what I would call the collaborative container is formed. There is a container where all negotiations and everything takes place within the container, within with the attorneys, with the other parties. Usually there'll be a financial neutral. Sometimes there might be a parenting coach. Sometimes there might be a realtor. There's neutral experts that are brought in to help you work through the situation. Okay. And when those people are brought in, they are part of the collaborative container. And you have a series of meetings where you will have to actually have meetings with your spouse and their attorney. And all these things are discussed to try to reach resolutions. For some people, that's great. Everything's discussed, everything's good. But for most people, it's not, because if you had great communication and felt like talking about everything in front of your spouse, then you probably wouldn't be getting divorced. For some people, it's good. I've done a couple really successful ones, but more often than not, we've had people come here when they've been in this collaborative process for a year or two and they haven't gotten anywhere. And part of the collaborative process is you agree not to go to court. You agree not to serve that financial discovery I was talking about. You agree not to do any of these things. And all of the negotiations are in this transparent process. That is good in a lot of ways, but it's not good in others, because sometimes you need basically that consequence of, hey, we could go to court on this, or hey, I have to get those financials because so-and-so's hiding them and I need to be able to serve a subpoena. So if you can't do those things and you can work together to resolve your case, that's wonderful. But it can take a while because you have to do all of the negotiation in the container. You have to have a series of meetings with the parties and you're coordinating a bunch of people's schedules, and it can take a while, and someone can really stall if they want to because there's no threat of going to court. So it is a process that is not appropriate when there are strong power and control dynamics, when there's been domestic violence, when there are substance abuse or mental health issues, where there's a nexus of abuse or parenting. Those kinds of circumstances are not appropriate for collaborative divorce. Sometimes it works out, but it also is not always the fastest, the best, or the most inexpensive. So that's what I'll say about that. But it is an option for you. I would recommend that you at least consult with a collaboratively trained attorney. There's a lot of really good ones in our area. And a really good attorney that does collaborative. I know some really good ones. I do it this much because I find it's not usually appropriate, but the people that really are passionate about collaborative law are the people that you should go to. And there really are some good ones. And the good ones will tell you like, hey, your case is not appropriate for collaborative if it's not. So that's one thing to know, but not everybody knows. And that's where you get trapped in the collaborative process when you shouldn't be there. So be careful. I'm also happy to give referrals for collaborative attorneys. We do them, like I said, but probably would rather refer you to someone else who's passionate about collaborative law. What I think is the most effective form of divorce negotiation is cooperative. And cooperative is kind of, I wouldn't say it's not a statutory process like collaborative. It's kind of something I've coined and other people have coined, where you agree to cooperate. You agree to exchange financials. You agree to try and resolve things through negotiation and mediation. But here's the thing. You can't force somebody to do that. You really can't. I mean, you can have as many conversations as you want to have. You can say, hey, we're going to exchange stuff on this date. And then somebody doesn't do it. And then what? Then you get off that cooperative track and you go to litigation. You might go to a hearing, or you might go to a mediation, which isn't litigation, but you might actually do that. And that can still be part of the cooperative process. But you agree to try and cooperate to avoid fighting about everything in court and ending up in like that temporary orders hearing this person was talking about, where you don't know what's going to happen. I mean, I think I know what's going to happen in most temporary orders hearings, and I've done like hundreds of them. And sometimes something happens and everybody's like, whoa, what happened? And then you can seek revision. And that's another thing that I'll talk about in a minute. But anyway, cooperative divorce, I think, is the most effective because you try to cooperate, you try to be on the same page with the other party, but you still have that option. If they're not doing what you want, you can go to court. If they're not doing what you want, you can serve discovery. If they're not doing what you want, you have options available to you that you don't have in the collaborative process, but you're still committing to like, hey, let's try to be on the same page about this. So I would say most cases fall into that realm where they try to be cooperative. Maybe they end up getting off track and have to go litigate or something, but then come back into the cooperative sphere. And then they end up resolving most of the time in mediation, sometimes in negotiation, but a lot of the time you need that third party to really like help you with the other side. So anyway, collaborative and cooperative. This other one is a full-on highly litigious divorce, and those divorces are not fun. They're not fun for the lawyers, even though they're really expensive. Well, most lawyers take no joy in that. I don't. They're not fun for litigants. I hate it the most because it's painful for my clients and their families. But sometimes a highly litigious case is necessary. I have one case. I've had a lot of litigious cases, but I do have one particular case that always comes to mind for me. And it's a client that I have worked with like 6 years now, maybe more. And no matter what my client does, and my client's a great person and a great mom, but no matter what she does, the other party, like, and we're way past divorce now. The divorce hasn't been going on that long, but in the divorce, we had to go to court for everything because the other party, like, couldn't get themselves together to agree on anything. And we had to get them to do anything. We had to go to court. And now, even post-divorce, to get them to do anything, we have to go to court, or they will do things where we actually have to go to court to stop them from doing things they shouldn't be doing. So a lot of the time sometimes the court has to make a decision. There are certain attorneys that just think you should never go to court. And I think you should not go if you can avoid it, because emotionally and financially it's difficult. But I believe strongly that I know actually that there are thousands of clients that we have helped and that other people have helped where spousal maintenance has been awarded to a mom who stayed home for a number of years, where someone got the money to take care of their family, where someone got protection from the court in a domestic violence situation, where someone got the right to use property they otherwise wouldn't have gotten to use because of decisions the court has had to make and because of litigation and advocacy. So sometimes that's very necessary, but you got to pick your battles, because other times you end up in there and you don't really need to be there, and someone's making a decision they didn't need to make and you have no control over it. So that is to say, a litigation divorce where you fight every step of the way and you end up in a trial is pretty rare, but it does happen. Collaborative divorce is the statutory process you have to agree to enter into. And then a cooperative divorce is kind of a hybrid. Sometimes you have one where you never step foot in court. Other times you might have to file a motion or go to court for something. Then you can get back on track and you can still cooperate and you don't end up in a trial. So those are kind of the most appropriate ways to go. I also would like to talk about the different kinds of mediation, because I think this comes up a lot. There's a lot of misconceptions about mediation and why it is effective and appropriate and the different types. Before I do that though, I do want to touch briefly on spousal maintenance, because this is something a lot of people like to talk about. Melissa, I believe we also did a webinar all on spousal maintenance not that long ago, right? Yeah. So hey, if you go to the YouTube library and you want to hear me talk for an hour about spousal maintenance, have at it. There's a lot of good information there. Generally, I will tell you this: spousal maintenance does not follow what I would call a statutory scheme. Child support does. There is a child support calculation and worksheet that determines how much child support is paid based on income. There's not for spousal support. There is basic case law that addresses spousal maintenance, and that case law and the statutory factors that do exist for spousal maintenance, they are just to guide a decision on maintenance and when maintenance is appropriate. A court is going to look at the length of your marriage. Is it a short-term, a mid-term, or a long-term marriage? They're going to look at the financial situation of the parties at the time of divorce. They're going to want to know a little bit about your marriage too, if like the incomes are wildly different and how you got to that point. But that's what they're going to look at. And then they're going to make a decision whether it's necessary or not. If the parties make almost the same amount of money and it's a midterm marriage, it's probably not going to be any maintenance. If it's going to be a short-term marriage, 5 years or less, probably not going to be any maintenance, because the objective, unless it's temporary, but the objective in those cases is to put the parties back where they came, and nobody's relied on the marriage enough. If it's a long-term marriage, there's going to be a general aim towards equalizing the parties, although that's not necessarily always the way it is. But usually in a long-term marriage of 25 years or more, there might be considerable maintenance if one party makes most of the money and the other party doesn't, and there's still working years left, which leads us to that earlier question. In a midterm marriage is most often where we see spousal maintenance, and in a midterm marriage, maintenance is awarded somewhere between I say somewhere because it's not a science. It's somewhere between 3 and 4 years of marriage equals 1 year of maintenance. In the case of disability or incapacity or other very extreme issues, you might see a different calculation, but it's somewhere in there. So there's not a right or wrong answer. There's a general range of risk that you can come up with. And if your case is within this range of risk, that's probably what's going to happen. So it makes sense to settle it on spousal maintenance. I could talk a lot more about maintenance, but that's some of the basics. I will also tell you that there is It's in something, a bench book that the judges read. It's in a lot of different things, and it's been quoted numerous times in cases. Maintenance in Washington is a quote unquote flexible tool. The court can use spousal maintenance to do equity. And this brings me to something I'll touch on in a minute as we get closer to the end, which is the division of community property. And we are not a 50-50 state. If you've watched any of my webinars before or come to my meetups, you've heard me say that we're not 50-50. Things are not automatically divided 50-50. Sometimes 50-50 makes the most sense, but not always. And so a lot of the time the court looks at the property division in the context of spousal maintenance. They look at them together because maintenance is a flexible tool to do equity, and doing equity means making a fair division. So they might say, I'm going to give one party this much money and I'm going to award maintenance. So I'm going to give 50-50 and this much money to one party. Or I'm not going to give any maintenance, but I'm going to give this party a little more. Or I'm going to do 50-50 and say no one gets maintenance. So maintenance is a flexible tool. There's not a right or wrong way to do it. You could go and do 5 different courtrooms on spousal maintenance and property division, the same set of facts, get 5 different outcomes, and somehow with the discretion the court has given, they would all be right. And you probably wouldn't have an appealable issue. So at the end of the day, an attorney can talk to you about a range of risk for maintenance, but there's not a formula the way there is with child support. So I'll talk about community property briefly, but before I do, I'll take like 2 more questions.
Okay. There are so many questions. I can't even believe.
I'll tell you what, we have 15 minutes. I'll go 5 after, so we have 20 minutes. I feel like a little more generous today to answer some of these questions. But again, keep in mind that we can't get to them all. I'll do my best. I talk fast, but only so fast.
Okay. What if I have a DVPO against me that is active and my wife or I file for divorce? Would that affect my ability to gain custody of the kids?
Yes. Yes, if you have, yes. And here's the thing, the DVPO is a bell that you can't unring. So some people will just be like, well, I'll just wait till it expires. Well, that's fine. And that will be helpful to you to a certain degree, but let's talk about what a DVPO is. DVPO is a domestic violence protection order. I think we did a webinar on these too. I did a protection order webinar not that long ago. Protection orders are a lot of different things, but I'll just touch on this briefly. A DVPO is a protection order that you can get if the parties are spouses, former intimate partners, family members, or household members. Okay. You have to be in one of those categories. So if you were married to this person and you're under a protection order because they filed and there was a finding against you, then you basically have in that protection order a finding of domestic violence, that you have committed domestic violence. So you have to be that certain category of former partners or spouses or family members. And then you have to there has to be a finding that you committed what is domestic violence in Washington. And there is a whole statutory definition for domestic violence. And now I remember I definitely did this webinar because I talked about the changes in our law. Our law changed in the past year to expand the definition of domestic violence. Domestic violence in Washington doesn't just mean I hit you. It doesn't just mean that. You would think, but it doesn't. And that's not necessarily a bad thing. It can also mean that you were in imminent fear that I was going to hit you because of something I said or did. It can also mean that you are a victim of coercive control, which can be a pattern of abuse, verbal, controlling behavior. And that's all completely nonviolent. It's a different kind of violence, but it's still domestic violence in Washington. Stalking is domestic violence in Washington. Physical assault, sexual assault, all domestic violence in Washington. So there's different ways you can have a finding against you. But your question was about parenting. If a domestic violence protection order has entered, you have a finding of DV. And when there's a finding of DV, the parenting statute basically says it can be a basis for entering. It is a mandatory basis for entering what are called 191 restrictions. If you ever hear that term, it refers to a part of a Title 26 and RCW, and the last part of it is 191. So everyone calls them 191 restrictions. They are restrictions that go in a parenting plan that can be a basis for restricting your decision-making and time with your children. It doesn't necessarily mean that it's going to be that way, but it is a basis for restrictions. And if you have a DV finding, unless there's no nexus between that DV and your parenting and your spouse, then you're going to have restrictions. And so what those restrictions are going to look like is going to be specific to your situation. How long ago? What's the situation? How old are your kids? Were they there? Were they involved? All of those things are going to matter. But it is going to have an impact on your parenting. It's at least going to be at issue. If you're no longer under the protection order and you've done the domestic violence treatment that was ordered and the protection order is in the past, then you have a better case for saying, hey, look, this isn't a current issue. If you are under a protection order right now, do everything and anything you can so that protection order will not be likely to be renewed when it comes up for renewal, because the other party can renew it. You need to do the treatment. Even if you don't know what that treatment is, find out, because it'll put you in a lot better situation to deal with potential restrictions in your parenting plan.
All right. So again, lots more questions.
I'll take one more and then I'm going to talk about community property.
Okay, really quick. Somebody's asking if you cover Snohomish County.
Yes, we cover Snohomish County.
If you're taking new cases and how they'd go about scheduling a consultation with you. We are going to put up a slide at the end of this webinar that will have Michelle's firm's contact information. So
yeah, we are taking cases. We're really busy right now. I'm going to be very transparent about that, to the fact that if you want to consult with me or another attorney here, you should do it as soon as you can. I think right now we're already booked out to consultations into October. So basically you'd want to get into our queue. We do cover Snohomish County, and yeah, we'd be happy to talk with you.
And if you maybe could refer to other attorneys if somebody had more immediate needs.
Yeah, if you had immediate needs, absolutely. I will tell you, almost everybody I'm referring to is in the same situation.
Right.
It's a really busy time right now. I don't know why. I think part of it, this is interesting, it's neither here nor there, but part of it is usually in family law, we see the summer be a little more quiet. People go on a vacation. They don't want to fight when their kids are home or whatever. But this summer, it really wasn't like that. It was a very busy summer as far as family law goes, especially for local practitioners in King, Pierce, and Snohomish County. So a lot of firms right now are booking further out. We're still taking people, but at the same time, and we would encourage you to schedule your consultation sooner than later. And we actually I have 2 attorneys that go to Snohomish a lot. I go there not as often as I used to, but especially now that Snohomish is requiring in-person. So I have an attorney that lives there that likes to go there a lot more. So that's why. But anyway, yes.
The other thing is, I know you're going to circle to community property. Again, we have tons of questions, but I'm reminded that you were going to talk about the different types of mediation. And there's a couple of questions about mediation. Is mediation the same thing as negotiation? Is mediation by a third party prescriptive? Is a mediator's decision final? So maybe talking about mediation would be.
Oh God, yes. Mediators don't make decisions. So yes. Okay. Let me talk about community property. I'll give you a high level overview on that. I think we did a webinar on that too. So you really should go to this is like just touching on a lot of things. So hopefully it's giving you some information, but if you want more of a deep dive, find the specific ones or just schedule a time to talk to me. Community property. This is a big one for you. If you are on this webinar, you've probably heard that Washington's a community property state. This is so true. What that means, what is community property? Community property is the property that's acquired during your marriage from the time your marriage begins, or sometimes community-like property if you were living together beforehand, all the way up until that date of separation. In that circumstance, you're looking at everything that was acquired, whether it was earned, given to you, anything. And it also means any debt during that time. So all of that goes into the community pot. Okay. And then once you know what that is, you got to say, is there anything in there that should be backed out because it's separate property? That can be gifts. So if one party was gifted something like an inheritance and they kept it separate, that's their separate, even though they got it during the marriage portion, it's pulled out. If one party has income that is theirs from before the marriage, like from a separate property business or separate property investments before the marriage, that's backed out, even though it was earned during the marriage because it's derived from separate property. If one party commits what I would call community waste, where they spend a bunch of money on something that definitely didn't benefit the community. Sometimes it's gambling, sometimes it's an affair, sometimes it's stuff like that. And it has to be a lot of money. It can't just be a drop in the bucket or a few dinners or a few turns at the slots. It's a lot of money for that to be waste. That is not considered community, and that should be debited to one party. That the waste claims are hard to prove. I have had some that have been pretty extreme. But anyway, that's another example of something that's an exception to community debt. During that time. If there is a mortgage and it's on a property that was owned prior to marriage, that's a separate property debt. Student loans beforehand, separate property debt. But if they're taken out during the marriage, and there's a whole case law on this, but they can be, and they typically are community. So anyway, so once you know what is in that community pot and what's pulled out, then you got to talk about how to divide it. So a lot of people think community property means we take a pie and we split it in half. And I used to do this when people would come in, I would like draw it because it made the most sense to me. And I'd be like, look, you split it in half, that's 50-50. That is not what automatically happens here. If you were in the state of California, they are a 50-50 state. and they're our biggest comparison for in the way that we do a lot of things. But what we don't do is divide everything 50-50 automatically. Sometimes 50-50 is appropriate, but Washington courts have a standard for division of community property that is just and equitable. What does that mean? It means it's fair. What does fair means? It mean, it can be anything. There's only one fair, right? It's going on right now at the Evergreen State Fair, well, Puyallup, right? It's still going on. Puyallup's the fair every year, right? Or there's the fair you pay on the bus. Neither of those are about how we're going to divide your property. Fair is probably not the same to me as it would be to my husband or to you or your partner. Like whatever. So what guides that decision are the things I've talked about: length of marriage, financial situation of the parties at the time of divorce, whether there are children in the home and support needs to be paid to them, and then the amount of assets and what the character of the assets is. So then the court looks at it and tries to come up with what's fair. It's not uncommon for a disproportionate division, which means more money, to go to one party than the other in a midterm marriage. It's not uncommon for a 50-50 in certain circumstances, but it's not an automatic 50-50. In a state like California, nobody would care how long you were married, how much money you made. Anything that was community would just be split 50-50. In Washington, there's a lot more to fight about, unfortunately. So, or fortunately, depending on what side you're on. So that's something for you to know about community property. The other thing I wanted to say about asset and debt division, this is so important. I'm going to say it. Do not fight over personal property in your case. Do not fight over anything that cannot be appraised. Recognize that if you have fine art that can be appraised, if you have expensive jewelry that can be appraised or that was gifted. If it was gifted to you, it's yours. Like a wedding ring is yours because it was gifted to you. Heirloom jewelry is yours because it was gifted to you. But if you guys bought some expensive stuff during the marriage, cool, get evaluation on that. But don't fight about how much the sofa is. Even I had once a $13,000, I think, restoration hardware sofa, and like an $8,500 love seat. And these people were like going tooth and nail over it. And the court was like, yeah, sorry, it's garage sale value, $150. So like, don't fight about it. And then you've already sent like a million emails and you spent more time arguing about it than it's worth 20 times over. Personal property is assigned garage sale value unless it can be appraised. Parties, just your attorney can help you try to work that out if you are just getting separated and you're stressed out about the household belongings, but it's not something to spend a lot of time on. It's like the easiest part of a case. So don't stress about the personal property. That is still community property, but it's personal property. Cars, kind of the same thing. It's easy to figure out a value. A lot of the time we don't even value them because we just say each party keeps their own because they're worth roughly the same, and used cars aren't a huge asset. So unless it's a real expensive car. So that's what I've got about debts and assets. Mediation. I'll take one more question, then I'll finish with talking about mediation.
Okay. So many questions.
I'm trying to help. I'll do two more.
Can my rights to my children be affected if I'm at fault for the marriage in terms of fidelity, that kind of thing? You know, can does that have any effect on parenting plans and things like that?
No. Washington is a no-fault state. So the story of your marriage will come out if you're in a trial setting. Like the court will need to know if somebody cheated, like they'll need to know like some of the background, but the court's not going to allocate money for someone doing that unless it directly related to like a waste claim, like I was talking about earlier.
Children have residential time with kids.
No, not unless you were doing something like, there's no fault allocated. Like you could have an extramarital affair and doesn't mean you're a bad parent. You could do any number of things. It doesn't mean you're a bad parent. If there was a nexus between it, like you were leaving your kids home, there has to be a nexus between your behavior. Like same thing with drinking. You could be somebody that drinks a lot and it's never affected your parenting and you've never done it around the kids, and that's not going to reduce your residential time. You could be having an affair and it has nothing to do with your kids or your parenting, or you could be having an affair and leave your young kids like home alone at night while you're gone with this other person and the other parent's out of town. That would have something to do with affecting your parenting time, but that would be like a neglect issue and a parenting function issue. It wouldn't really matter where you were. So fault can't be allocated financially for a divorce unless it directly relates to waste or money that somebody spent. You can't get emotional damages for emotional abuse in a Washington court in a divorce case. There's statutory and case law on that. You cannot be compensated for that. So some people will want to say, oh, what can I bring a civil claim later? That's for you to talk to a civil attorney about.
So I'm going to turn it back to you to talk about mediation and kind of finish with that. And I just want to say to the rest of the crew here, apologies that we were not able to get to all your questions. There's so many asked today. I really want to encourage you to reach out and schedule consultation if you can. I'm going to put up the slide here with our contact information while Michelle's talking. Please reach out to her firm or another firm to get your questions answered. If anybody has any counseling needs, feel free to reach out to me. Okay, but I'm going to
Yeah,
let Michelle finish up by
absolutely.
talking about
That's something I usually talk about too, is that you should talk to a counselor about your issues, because I love to hear about them, but I can't help you the way that she can, or another counselor. Also too, I would love to take more questions, but I am actually on a vacation, just got home from a vacation, and I have slept about 2 hours last night because my flight was delayed. So I'm pretty tired today, and I still have a little more vacation after this. So this is a happy interruption to my vacation though. All right, so mediation. Is it good? Is it bad? Is it required? Yes, it's required in most cases. Most counties have what we call a dispute resolution requirement. What that means is that before you go to a trial, you are required to participate in alternative dispute resolution of some kind. That's typically mediation. Before you go to a trial. It doesn't mean if you have domestic violence, a finding of domestic violence, that requirement is typically waived. Although I have had it happen recently over the last, since COVID, because now mediation is very much over Zoom most of the time. Sometimes my clients will actually come in and sit with me, and then we'll have the mediator on Zoom, but we'll sit together. A few times even I've gone to do mediations in person. They used to always be in person. And the reason that mediation was waived when there was DV is because there was a requirement that you not be within a certain, 500 or 1,000 feet of the other party. And that'd be pretty hard if you were in somebody's office building, even though you never saw each other. So now that it's over Zoom, a court will very often waive the lack of requirement and want you to go to mediation. A court wants you to go to mediation before they have to decide about your parenting time and your money. They don't want to make those decisions. They really don't. Courts don't like family law trials. That's just the reality. We kind of like doing them sometimes, but they don't want to hear them. So mediation is required. Or some kind of dispute resolution is. Mediation can look very different for different people. I believe mediation is highly effective when parties aren't getting anywhere negotiating. You should go to mediation, because otherwise you're spinning your wheels trying to force something to happen that's not going to happen. And a lot of people are scared of this process. And I think that makes perfect sense, because it's unknown, right? You never done this before. I've done it 1,000 times or more, and I know how it works, and I'm very confident in it. You're not. I get that, right? So first of all, the most common mediation, if you have counsel, and in my opinion, the most effective, and I've done all the kinds of mediation that I'm going to talk about, the most common is what's called a shuttle mediation. It's effective because you're not sitting there with the other party, and you're not hearing the stuff they're saying, and you're not seeing their facial expressions. What you are doing is you're in one room with your attorney, whether that's a Zoom room or whether you're sitting together in a conference room, you are with your attorney. The other party and their attorney, you will not see the entire day. The neutral attorney mediator will shuttle back and forth between the two rooms, either in person or on Zoom, and they will carry offers back and forth. And they will do what is called an evaluative mediation. I cannot stress to you enough how much more valuable an evaluative shuttle mediation is than any other kind, in my professional opinion. An evaluative mediation means you have a mediator who is a neutral, who has no dog in the fight, who is evaluating the positions of the parties. You've already heard it from your attorney. You've heard like what your range of risk is. I might tell you your case is going to settle somewhere between 45 and 50-50, probably right in the middle of that. Or your case is definitely a 50-50 case, or yeah, it's your, whatever. Anyway, you have like a range of what could happen, but sometimes clients need to hear that from someone else. Sometimes clients need to hear that, this is what I think could happen from somebody who is a neutral. And it's not just about property division, it's about everything down to the little details. They carry offers back and forth, and as the day goes on, they evaluate positions to help the parties get more real about settling. And it's very effective. I have done many, many mediations, and it's hard to quantify it percentages wise, but I would say over 90% of them settle. Even cases that have been highly contentious, highly litigious, they settle with the right mediator. Different mediators have different styles, but an evaluative shuttle mediation is extremely valuable to the parties. It's an expensive day, but much better to spend the money on one day than a long drawn out trial, or to have your case just keep going on and on. So highly recommend that. Other types of mediation are what I would call a facilitative mediation. This mediation is most common when parties don't have counsel. They go to a neutral. That neutral might be an attorney, but not your attorney, because they can't represent you in the process. They are there to facilitate the communication between two parties and help them come to an agreement. They can't give either party legal advice. In a shuttle mediation, you're getting legal advice the whole time from your attorney. In a facilitative mediation, that person can't give either side legal advice because they are not an attorney to either of them, even if they're an attorney helping facilitate the process. A lot of the time, you also cannot sign sign a binding agreement in a facilitative mediation. You can, or most facilitators won't let you. You can in a shuttle mediation, and you do. You leave there with a binding document that nobody can get out of. That's the idea. In a facilitative mediation, you will leave there very often with what's called a memorandum of understanding. And it's just that. It's a memorandum of what we understand we agreed to. But it's not binding on anybody. So you might have spent days doing that, or one day or whatever. And then you take it to somebody to look at and say, hey, is this a good deal? Should I agree to this? And somebody's probably going to say, why would you agree to that? It's your worst day in court. Or sure, it's a good deal. But anyway, a lot of the time people have brought them to me and I've been like, if you do that, that's fine. We'll draft it for you, because we have to have someone else draft the paperwork. The mediator doesn't do that for you usually. And you can do that, but you're probably losing a couple $100,000, or you could be losing this or that or whatever. And sometimes it's too much. Other times it's not a big deal, or other times it's right on the money. But a facilitative mediation is one where the mediator is facilitating face-to-face contact with you and the other party. That's not for most people, but to each their own. The other kind of mediation is collaborative, which is not necessarily mediation. It's the collaborative process where everyone talks and negotiates in real time. So there's that kind. And then there is also roundtable mediation, where you roundtable with both parties and a mediator. Anytime I've done that, which I won't do it anymore unless somebody's really pushing for it, the parties will separate and go into other rooms. Mediator will be like, this is not happening, so we're going to go in other rooms if we're going to have any chance of settling this. It's everything from someone else's body language to whatever that can set you off. And it's really much better for the parties to have privacy to get their own advice. So roundtable mediation, shuttle evaluative mediation, facilitative mediation, collaborative process, open discussions and collaborative process. Also too, another form of dispute resolution is arbitration. Arbitration is can be on written submissions where you submit something in writing, arbitrator makes a decision. Arbitration can also be with testimony instead of a trial. So arbitration is a whole other process I don't have time to talk about right now. But mediation, big fan, because it settles most cases without a trial. And again, required in not every county in Washington, but most have a dispute resolution requirement. King, Pierce, and Snohomish all do. I don't remember if Thurston does. Kitsap does, and they have a great process. They have a settlement conference process. You don't even have to hire a private mediator. One of the other judges who's not assigned to your case will do a settlement conference with you. So that's an option in Kitsap and some other counties. So anyway, I will take one more question, Melissa, because I'm feeling it's 1:06. I'll take one more question. I said I said 1:05. I'll go to 1:10. I'll do one more question before you wrap it up, because I know there's a bunch of them.
Sure are. How do I even choose? Okay. Okay, if an ex-spouse is harassing or using very bad language on OFW, are there legal options?
Yeah.
There's a couple OFW questions, another one kind of about, I'm trying to group some things together so that
Why don't I just talk about OFW for a minute?
yeah. And I'm also just maybe kind of like abuse allegations and how it pertains, and the idea of kind of using this and what can be done if it's used improperly.
Yeah, OFW is a great program. It stands for Our Family Wizard. There's also Talking Parents. Those are the two most common. There's also a couple others now too that have kind of come into the marketplace, but Our Family Wizard is the one the court will order, and Our Family Wizard's not that expensive. I think right now it's $119 a year for each party, so it's like less than 10. It's like $10 a month. And it gives you access to a platform that basically stops the need for text messages and that kind of communication between you and the other party. It stops that, because all communication has to be in that platform. There's an app for it, but it basically lets you draw boundaries for your communication. It also has a timestamp for when someone's read it, so someone can't be like, I didn't get your email, or I didn't see it. You don't have to be afraid of every text message going off because the other party can't text you. So using OFW is a good way to do that. But what if someone's being abusive? Well, attorneys can also be given access to OFW. I have OFW access on a lot of my clients where I can go in and see the messages. Or sometimes clients will just send them to me. Court is very familiar with seeing these kinds of messages. And if someone is being abusive, that could be something that could be used to support requests for temporary orders, a protection order, contempt, if they are in contempt of one of the provisions of the parenting plan by doing that. So yes, you can use those messages in court. It's a great documentation tool, which is kind of the other reason besides just drawing boundaries that most people use it. It's used in high conflict cases and also cases just where people seem to have communication difficulty. Parenting coordinators, guardian ad litems can also have access to your Our Family Wizard if you give it to them. So it is very commonly used. false allegations happen all the time in divorce. I wish they didn't, but it's just part of what happens. Everybody's a narcissist. Everybody's abusive. I'm not saying that some people don't have narcissistic tendencies. There's a big difference between being a diagnosed narcissist and having narcissistic tendencies. There's a big difference between saying you're a victim of domestic violence and really being one. Sometimes people will say that to get an advantage in a custody case. All of these things happen. It doesn't mean there isn't real abuse. It doesn't mean there aren't really mentally ill people, but when these allegations are literally in almost every case at some point that makes its way into court, it makes it really difficult for the court to cut through what's true and what's not. So my advice to you is, if you have documentation in OFW messages, text messages, Facebook messages, I guess people don't use Facebook Messenger as much. I think they use Instagram or Snapchat or whatever now. But anyway, long story short, any kind of messages like that, any texts, anything you have that documents your claims, you want them, because if it's just a he said, she said, court often doesn't know what to do. So more documentation is better for any claims that you want to support. I hope this has been helpful. Thank you for coming and participating. Thank you for checking out the other webinars. I would have loved to have gotten to so much more today, but this is about the end of what I can do today. So appreciate you, and thank you for coming, and thank you to Melissa for facilitating. I wish you all the best, and hopefully I'll see you again next time on a webinar. I will give a shameless plug as well for our meetup group. We do have a meetup group. I think it's actually going to be in person this month, at the end of the month. We do meetup group usually twice a month. You can also find information about this on our website. And it's not just me talking, I promise. There are actually other professionals there. Melissa's there. We have a CDFA there. We have a real estate person there, a lender there. We talk about your questions. We talk about very real issues. It's a good supportive environment. We have it on the Zoom platform. It's very much Q&A. And then we once a month in certain months meet in person in Bellevue. So there will be one, and I don't know if any spots are still available, but you can check it out. If not, that's next Wednesday, I think September 27th. And then there will be some in October as well. I think one virtual and probably one in person. So hope to see you at one of those, or see you in a consultation soon. Thanks, and no matter where you are in the divorce process, I wish you the best. Take care.
Take care, everyone. Thanks for coming today.